Hi, everybody. So today we're going to talk about employment law in this lecture. And this is basically a subset of contract law, which I gave you an overview of contract law in the previous class. Now we're going to look at the specific area. And so what I'm going to talk about, first I'm going to give you like a really kind of basic introduction to what is employment law. Then we're going to look at an overview of the law, give you like kind of bird's eye view of it. And then we're going to look at a few specific issues that arise in the context of employment law, which are different from what happens in other contracts. So things like overtime, the hours that people can work, minimum wage. These are terms that are imposed that limit freedom of contract, which I talked about in the last class. Gender discrimination. This is a very big issue in Japanese employment law, or Japanese employment in general, I should say. And there's some weaknesses in the law that allow it to persist. We'll look at those a bit. Firing workers. What are the rules that protect, basically, what are the rules that protect workers from being fired, losing their employment contracts? Talk a little bit about long-term employment. This is a Japanese system, not just Japanese, but implicit contracts that a lot of workers have, that they work, they get hired when they graduate from university in their 20s, and then they work until retirement. That's an informal system. Not all workers are covered by that. In fact, most are not, but we'll look at a little bit about that because employment practice is a bit different in Japan. And talk a little bit about demographics, how that's affecting the employment situation in Japan. And finally, the difference between contract and permanent workers. So what is employment law? So I kind of I alluded to this a bit in the previous class about contract law. Employment law is an area of law that it's an area of contract law, but one which we treat differently from other areas of contract, partly because of that difference in bargaining power, which I talked about. Employers, like the people who hire people, generally have more bargaining power than employees. There's a few exceptions, but largely that's true. That's also the case in like consumer law, which I used an example in the previous class. But employment law, you have some real concerns because what you are contracting for is you, like your time. Human labor is what we're talking about here. And so there's a lot of concerns that don't arise in other contracts about like basically human rights, human dignity, safety. It's a much different type of contract than just contract to buy like a bottle of peanut butter or whatever. So so we have to have a lot of rules that put limitations on that general principle of freedom of contract. We don't want there to be employment contracts under which employers put really unfair or abusive conditions on employees, because I mean you're selling a huge chunk of your life when you enter into an employment contract. We want you to be able to live your life with some dignity. Law doesn't always perfectly achieve this, but we want to at least avoid like the worst case scenarios which can happen without it. So if we look at the law, the Constitution, remember when we talked about the Constitution, there's a provision in there related to employment, Article 27, which is all people shall have the right and obligation to work. Standards for wages, hours, rest, and other working conditions shall be fixed by law. Children should not be exploited. So this is the Constitution speaking. So I won't repeat what we said in the class on that, but you have the right to work. The obligation doesn't mean that you can be forced to work. It's very important. That's not what this is saying. That first sentence is more or less like an aspirational one. It doesn't really have any teeth. But the second line, that standards for wages, hours, etc. That means what that provision in the Constitution says is that the legislature, the Diet of Japan, must pass legislation that fixes these things, that doesn't leave it up to just freedom of contract to decide, what wages can be paid, what hours, how can you make someone work 24 hours a day, 7 days a week. No, we want to put limitations on these sorts of things. So this is saying the legislature has a constitutional obligation to provide some sort of legislation which puts limits on those. And child labor, not exploited, not allowed. Children, child labor, which is simply not allowed in Japan. Now, there are different pieces of legislation that deal with different things. The Civil Code, Chapter 8, does deal with employment. And we saw, like in the previous class, like that last case that I talked about with the idols, that like I said, that was a bit unclear at the beginning of the case, but that turned out to be treated as an employment contract, which meant that the terms for terminating an employment contract were applicable to that dispute. So Chapter 8 of the Civil Code does that the rule and several others are included there, and those are probably kind of like the default rules for employment contracts, like how they're formed and what conditions, under what circumstances you can cancel or terminate them. So like Article 623 says an employment contract shall become effective when one of the parties promises to the other party that he or she will engage in work, and the other party promises to pay remuneration for the same. So that's what an employment contract is. So the Civil Code, it provides some of those like basic rules, but all those other things that we just saw in the constitutional thing, like working hours, wages, safety things, none of that is included in the Civil Code. The Civil Code is just providing the rule, the really, really basic rules of like what is an employment contract, how do you cancel it, and these things. Those other things are governed by other legislation. And the main piece of legislation that governs those is the Labor Standards Act. This is the thing. This is the law, the piece of legislation that puts a lot of specific limits on things that can be included in employment contracts. Things like work hours and stuff like that. So if we look at some of the issues that come up in employment contracts, and most of the rules that we talk about, we're going to look at some of those rules from the Labor Standards Act. So one of those is like work hours and overtime. So the default rule in the Labor Standards Act is like an 8-hour day, 40-hour week. That's the standard. It's Article 32 of the Labor Standards Act says that. But there are many exceptions, and also that rule is often ignored. So you're supposed to have like a 40-hour work week, which means if an employee works more than that, they're supposed to get overtime. And that's good, but that's like 40-hour work week is that gives you time to have a weekend off and a little bit of time in the evening to yourself, which is what a normally functioning human can benefit from. So that's why I put it in there. But Japan is kind of notorious for the long hours that many of its employees work. And this is in 2016, the government actually did like an investigation into the overtime problem, like how much overtime people are doing. And this white paper found that about 20% of the workforce is at health risk due to overwork. They're working so many long hours that their health is at risk. Now, if everybody was following what the Labor Standards Act says, and everybody has a 40-hour week, 8-hour days, stuff like that, this shouldn't be a problem. But we have, I put a couple of examples on the slide here. Like you have this problem of karoshi, like people die, actually working so long that they actually die. There's this Matsuri Takahashi case. She's a 24-year-old Dentsu employee, and that's like a very big like advertising agency, who committed suicide in 2015 from overwork after logging in more than 100 hours of overtime in the months leading up to it. So 100 hours of overtime, like in addition to like the full-time hours she was already working. That's an incredibly large amount of time to force a human being to work. And then there's this Sado case from NHK who suffered a heart attack in 2017 after 159 hours of overtime in a single month. Like 159 hours by itself is like a full-time job, and this is like on top of regular hours. So she was basically working the equivalent of like double what would be like a normal 40-hour work week. So why does this happen? How is this allowed to happen? So like I said, the Labor Standard Act has a standard 40-hour work week, but there are a lot of exceptions to that. It doesn't cover all employees. Um, employees in certain professions are completely exempted from it, like lawyers and stuff like that. There's no regulation of their hours, and that's one way. But another way, probably like for most employees, is much bigger. Is that it's simply ignored. Uh, employees will be given, like a standard 8-hour shift, and then there'll be like other stuff kind of informally added to usually the end of that requires them to stay in the office, kind of off the books, sometimes for many hours more. And that accumulates over time. Employees just, they don't object to this. They feel like maybe informally pressured, what have you, to stay. And lots of employees end up working like incredibly long hours, even though on paper they're only getting paid for, like a standard for a 40-hour work week. So that might be kind of like a cultural work culture problem that some employers, like, they demand, like, employees stay. There's kind of like an informal, unspoken rule at some workplaces that nobody can leave until everybody in the office is finished, and so people will often have to stay maybe like several hours after they've done all their work, just because they're waiting for their other employees, their coworkers, to finish something. These weird things that crop up in a lot of workplaces that kind of encourage employees to stay for long hours. And sometimes they just like their employers simply give them too much work to do and not enough time to do it. There's like unreasonable demands being put on people. These ones who die from overwork, those are almost often people who have been given a million, not a million, but a huge amount of things to do, and left to their own devices. They just don't have enough time during a regular working week to do that, and they end up really piling up all this overtime. So in 2018, there was a reform, kind of a partial reform, like it came into effect the year after, which at least it was stated to be for the purpose of responding to that problem of like excessive overwork and karoshi. And they added a couple of provisions to the Labor Standards Act. I should mention too, the Labor Standards Act, in addition to like just being ignored in certain professions, you can work overtime, like officially overtime. That is permitted. You're supposed to get paid for the overtime. 40 hours is sort of like the standard, and then you get paid for what goes up above that. Although most of the time though, overtime, when people say overtime, they don't mean like paid overtime. It's usually like this sort of like informal unpaid stuff that people get pressured into. But they added some provisions to the Labor Standard Act that was meant to cap that formal overtime, that maximum of 45 hours per month or 360 hours per year. It's like those two cases where somebody died, they were working more than 100 hours of overtime a month. So this is sort of meant to, okay, we got to make sure people don't put that much time in. But then that's the first rule. The second one though says, this is my second like sub bullet point here. But if an employer really needs to, due to an ordinarily unforeseeable significant increase in workload, they can require up to 100 hours of overtime per month or 720 hours per year. That's Article 36 sub 5. So this is why like a lot of people have been very critical of this reform, because the first part, 45 hours maximum overtime per month, that's except like 10 hours per week. That's still a lot of overtime, but it's at least that's at least like within the realm that your health isn't like at risk. It can be busy, but not like insanely busy. But then they put the second provision in that says, oh, but if you really need to, you can do 100 hours. And 100 hours is when doctors say your health is at risk. 100 hours of overtime a month, that's like 25 hours a week roughly, on top of like a 40-hour work week that you're already working, is enough that you're getting to that karoshi danger level. So like this reform, which was meant to like it's kind of like officially it was meant as a response to that problem, doesn't really solve it, because it still allows practices that that are dangerous to people. Also, this reform, some of the other exemptions it doesn't close. Like if you're a lawyer or like certain professions, there's no limit on their hours before or after this reform happened. So, so overtime is still like an issue that there are rules in the Labor Standards Act that are meant to deal with it, but it's still a big problem in the Japanese workplace. Not all Japanese workplaces, but busy ones. So a second issue that comes up, which we need legislation to deal with, is minimum wage. Minimum wage is not dealt with in the Labor Standards Act. It has its own piece of legislation, the Minimum Wage Act. And under that act, each prefecture in Japan has its own committee that can set its minimum wage, like the hourly minimum wage, every year. So every year it gets updated. And so what happened as a result of this, each prefecture has a different minimum wage. As of like last year, 2023, the highest is Tokyo with 1,113 yen per hour. The lowest is Iwate with 893. Here in Aichi, we're like a little over 1,000, I think. We're kind of in between those two. You'll note that, like, especially for Tokyo, this is like not a lot of money. The minimum wage, 1,113 is like what, $8 US per hour. Good luck trying to live in Tokyo off of that. Or even Iwate Prefecture, 893 is not very much either. So the amount, I've been watching it for years. It goes up a little bit each year, but we're talking like a few yen. So cumulatively, raises in the minimum wage haven't kept pace with the rises in the cost of living. So this is very like I would say out of date, but it's not adequate. A lot of jobs, of course, have to pay more than the minimum wage because not many people will want to work for that much, especially in big cities like Tokyo. Anyway, that's where minimum wage comes from, though. Another big issue that comes up, and this is, yeah, Japan's particularly bad at this, is gender discrimination. Japan, I didn't check this year's, but last year's they were 120th. They were ranked 120th in the World Economics Forum, like ranking of countries by gender equality. Like Angola and Sierra Leone, like we're sandwiched in between those two. Really like hyper unusual for like a wealthy country, the like economically developed country, to be so lowly ranked. Like most of Europe and North America are, you know, the top 30 or 40. And that specific international ranking, which is the one that gets cited the most, it bases it on several things. 4 things. It's like political representation. Japan scores very low on that. Like the number of females in political positions, like in members of the Diet, it's very low compared to other countries. Like roughly 10%, I think. Don't quote me on that. It might be a little bit off, but very low representation in politics. Education. Actually, Japan scores very low in political representation, very high in education. So there's rough parity between like the genders in terms of like access to university education and things like that. Healthcare. Healthcare is another one where Japan scores highly. Like male and female populations, there's not like discrimination in terms of access to healthcare. Roughly like even. But the 4th one is employment, and employment, and along with political representation, are the things that drag Japan's score down. Very like rampant systemic discrimination based on gender happens in lots of workplaces in Japan. And one of the statistics that probably like best illustrates this is this one I put on the slide here. The regular employment rate for males is 77%, and the regular employment rate for females is 43%. What that means is, by regular employment, what I mean is employees who are permanent full-time employees of their employer. 77% of men in the workforce are permanent full-time employees. Only 43% of females are. Now, if you're a permanent full-time employee, like was what I mean by regular employment, you have job security. You generally have access to things like promotions and raises and just generally better conditions. If you're not in regular employment, means you're either like a part-timer or like baito, or you might be full-time, but you're on a fixed-term contract. Like you've been hired for 1 year, and after that year, you don't know what's going to happen. So your employment situation is more precarious. Your income is lower. Your opportunities for advancement are also lower. And as you can see, there's a pretty big gender gap in, one of these is kind of like a privileged position within the employment system, and the other is not. And men, are given like more of these privileged positions than women are. So the gender discrimination, that's not the only thing, but that's one piece of data that kind of demonstrates it. Now, the Labor Standards Act does have some rules on gender discrimination. It's actually Article 3 and 4. I'll just read them here. So Article 3 says, an employer must not use a worker's nationality, creed, or social status as a basis for differential treatment with respect to wages, working hours, or other working conditions. So this is like the anti-discrimination rule in the Standards Act. Note what is missing there, though. Nationality, creed, or social status. Does not say gender. So this does not prevent gender-based discrimination based on wages, working hours, or other working conditions. Article 4 does deal with gender discrimination. It says, an employer must not use the fact that a worker is a woman as a basis for differential treatment in comparison to men with respect to wages. So that's a lot more narrower than Article 3, right? Article 4 just says, like, basically, you cannot engage in wage discrimination between men and women. But these other things, like working hours, working conditions, also hiring policies and stuff like that, doesn't protect against gender discrimination from that. So this huge gap that these two rules, and these in the labor, there's more legislation, so this is not the end of the story. It's not quite bad, but actually, like the Labor Standards Act was passed like after World War II, and for many decades, this was the only law that dealt at all with gender discrimination in the workplace. And as you can see, it has like huge holes in it that probably over time allowed like the current like situation to come into existence. Not that the only thing, but like, there's a lot of things that contributed to gender discrimination in the workplace. But the fact is that the law didn't address that problem at all. And this law helps to explain, at least in part, why that situation exists. Now, to fill that gap, like that glaring hole in the law, I mean, it wasn't like unnoticed. Eventually, the Diet, we're fast forwarding here, like the 1980s, passed a separate piece of legislation to like plug some of the hole in the Labor Standards Act. It's the thing called the Act on Securing of Equal Opportunity and Treatment Between Men and Women in Employment. And this adds some supplemental rules that deal with that. So Article 5 says that there can be no discrimination in hiring between men and women. Article 9 said you're not allowed to require retirement for marriage, birth, etc. So until this rule came into effect, the Labor Standards Act did not protect women from their employers having policies which terminated their contract for getting pregnant or getting married. And I mean, we can go back to my discussion and my criticism of like that idle no dating clause case in the previous case. This is another example of like an egregiously invasive discriminatory rule in a contract that used to be okay. I mean, they had to pass this legislation to specifically say, no, that's not okay. You cannot fire someone for getting married or for getting pregnant or for having birth or anything like that. Now, note though that this only applies to requiring someone to retire to end their career. It doesn't say that, it doesn't address like other things that might come up with that. Anyway, Article 11 says, employers should adopt measures concerning problems caused by sexual harassment in the workplace. So this is the harassment and discrimination are like different things. Discrimination is like differential treatment. Harassment is, harassment. Sexual harassment, technically sexual harassment can go both ways, but overwhelmingly it's men like harassing women. The Labor Standard Act says nothing about it. This rule says that, and this is also something that has problems. So this is like the first time that you have the Japanese law legislation saying, sexual harassment in the workplace is wrong. But note, this says employers should adopt measures concerning problems caused by sexual harassment in the workplace. Does not say sexual harassment is not allowed, right? It's just putting it should, not must. That's an important distinction too. Employers should have some sort of like measure to do something about sexual harassment. What that measure is, how effective it should be, etc., not addressed. You just have to do something. You could do something that's really, really weak and still comply with this. So this is as a law that's going to like deal with sexual harassment. This is basically saying we're not going to deal with it. We're going to put a kind of like very, very weak requirement, or more like a suggestion, really, that employers have some sort of policy, but we're not going to ban it. We're not going to put any penalties associated with it, etc. So, so sexual harassment is also something that, like, right, not just a problem in Japan, of course. Any country has this, but the legal system, the laws, the rules that exist are fairly weak at controlling it. Like one example of this, it's a few years ago, it's like 2010, but this Rina Bovrise Prada case, like Prada, the famous brand, fashion brand. Prada, Rina Bovrise, she was like like a managerial level person, employee at Prada in Japan, and there was a high profile case that happened in 2010, in which but she was fired for complaining about sexual harassment, as I say on the slide here. Basically, her complaint against Prada. So she fired. She was like a manager, as I said. Prada had policies for evaluating and promoting employees that were heavily tied to looks, and this almost exclusively applied to their female employees, where if you wanted to be like the manager of like one of their big stores, if you didn't look good enough, like according to their criteria, like you got old or something, they would remove you from your position. This is not something that that normally should be allowed in employment law. It actually is allowed in Japan, but I'm critical of that. If you're going to get fired or demoted, it should be something because you did something bad, right? I think that's a fairly safe principle of what we would consider like fair. And coming from Canada, like kind of influenced by the rules there. But like physical appearance is definitely not something that's always inside of your control, and it's not really like a valid. Well, I would argue it's not really like a valid criteria for evaluating someone's performance as like a sales manager or something like that. But Prada had these policies, and she criticized these, and she actually criticized them publicly, and was fired. And also that's actually like more like a discriminatory thing, but she was also fired because she had complained that her superiors had, in a culture, like a work culture where, employees are evaluated that way, you can imagine that there's a lot of sexism and sexual harassment going on, and she was subjected to a lot of comments. She complained about that. She was fired. She sued, and actually they sued her. Prada sued her for having made these complaints publicly. Sued her for defamation, and won. And Japan's legal system was highly criticized for this. Because it seemed like the legal system was actually like punishing a whistleblower for revealing that sexual harassment occurred, and not because the sexual harassment didn't occur, but because by complaining about it publicly, she had embarrassed the company that was engaged in sexual harassment. It was pointed out that this isn't a very effective way for dealing with sexual harassment as a legal system. And that's sort of like a continuing problem. So gender discrimination in Japanese employment, there have been rules added like over the years, but there's still a lot of like glaring deficiencies in it, which are not the only thing that explain like the gender gap in regular employment, and as a result of that gap, you have differences in also like wages, seniority, and these sorts of things between the two genders. But it does help us to understand why they persist. And we looked a lot to solve these problems, and they really haven't so far. Another issue we can talk about in employment law is the issue of firing workers. So like in the class on contracts, I already introduced you this Article 628 of the Civil Code. If you want to terminate an employment contract, you need an unavoidable reason. In the case we looked at there, it was like the employee, like the idle who wanted to terminate the contract. Same rule applies to like the employer if they want to terminate a contract. They need an unavoidable reason to justify terminating or firing you, basically. The Labor Standards Act does put some limitations on the ability of employers to exercise that right. As I say on the slide here, it's like Article 19. They're not allowed to fire people during like postnatal leave. Like if you have a baby, I don't mention it in here, but you do get like some statutory time off that you're allowed to take. You're not allowed to be fired during that time, or if you've been injured. In a workplace-related accident, there's separate legislation that deals with that situation. But under the LSA, you're not allowed to be fired like during your recovery of that. But actually, more important than that, in terms of like a limitation on the ability of employers to exercise their right to fire somebody, is Article 1 of the Civil Code, that abuse of rights provision I talked about in the class on contracts, that applies to everything in the Civil Code, but it's very, very relevant in employment law context. Basically, the courts over the years, they've used that to put limits on the ability of employers to fire people. Like I have on my slide here, the NHK case. For a cause, rejected, oversleeping guy. What that case was, the case from the 60s, this was a radio announcer for NHK, like the national broadcaster. And his job was to read the news at a given time on the radio. And one day, it's his turn to read the news, and the radio is just dead silent. Shh, nothing's happening for like a couple of minutes. The reason was he fell asleep. He was taking a nap. And he overslept, and he didn't wake up in time to go and read the news. And somebody eventually like, oh God, wake him up. There's nobody on. They eventually woke him up, and he did it. But he was fired for that. So he committed, like, that was his fault. This is what I say, for cause. If the employee gives you a reason to fire them, in just circumstances you're allowed to fire them. And oversleeping might be one. But the court, so they fired him, and the court was asked. He sued to try to get his job back, saying, like, well, okay, I might have done something bad, but and under the terms of our contract, my employment contract, maybe there is a provision that allows them to fire me for certain, doesn't say like oversleeping specifically, but for cause. But you should hold that it's an abusive right for them to fire me in this circumstance. And in the case, like he was the employer was able to establish that he's a good employee, hadn't had any previous incidents like this, and that the reason that he had slept too much was that there's actually like another employee whose job, well, not his only job, but one of his jobs was to wake him up, make sure he was on there, and that employee had also fallen asleep. He was like in a nighttime shift, so it wasn't entirely his fault that he had failed to wake up. Anyway, the court held that, like, given those circumstances, like all this context, the employer resorting to firing him, as opposed to something like short of firing him, like disciplining him or suspending him, giving a warning and stuff like that, constituted an abusive right. So the courts since then, and we saw this a bit with like some of the other cases I talked about last week. Some of those were employment ones too. When it comes to employment contracts, the courts are generally inclined to, unless the employee has done something really, really egregiously bad, to use this abusive right doctrine to say that, yeah, employers, exercising your right to fire someone, like, unless the circumstances are really, really drastic, constitutes an abusive right. You should instead, like, if they do something bad, you should use measures to correct them that are short of firing them. It's kind of like the final resort. Another on the slide here, this for economic necessity part. Another type of firing that sometimes happens is when not an employee gets fired not because they did something bad, but because the employer, like the business, has an economic reason to do so. Like their business is not doing well. Like if a company is losing money, maybe it needs to lay off or fire some workers because it needs to close a factory that's not making money, or a store or something like that. So in that case, like you've got an employer who's going to fire somebody, or maybe like several people, but those people didn't do anything wrong to justify it. They didn't give any cause. They didn't oversleep or do something bad. And the courts have, especially in those type of cases, courts have also used this abusive right doctrine to hold that actually, employers, we're going to put like somewhat strict conditions on your ability to fire workers, and even if you might otherwise be able to. And as like Toyo Oxygen case, it's an older case, but it's kind of like provides like the basic rule that there's like a like a 3-step test that employers must satisfy if they want to engage in mass layoffs where there's no fault by the employees. So first, like if you're going to close like a factory or some office or whatever, you must be able to show first that closure is unavoidable for business reasons. So in other words, sometimes businesses decide to close like a profitable division because they want to use the assets to do something else. You can't do that. It has to be like an unavoidable closure. You've tried everything you can to keep it open, and it's just not going to work. So you have to prove that, and you have to show that for these employees that are going to be infected when you close your factory or your store or whatever, you can't. There's not other jobs within your company that you can just transfer them to. You have to try to accommodate all of them, transfer them before you fire them. And it's only if it's like impossible to transfer them that you can resort to firing them. And 3, you must have objective criteria that are used to select employees to be dismissed. So if you have like X number of employees that you can't accommodate by moving them somewhere else, and maybe you need to fire like 50 of them, you have to have like some sort of like method of choosing who are those 50 people that we need to fire. Who are they going to be? Can't be just random. Maybe you're going to use people who are like closest to retirement or something like that. You have to have some sort of objective means. And it's only if you can meet all these three criteria that you're allowed to engage in layoffs. So one effect of this is that it makes layoffs, like large-scale firings, legally much more difficult in Japan compared to the United States. In the United States, not all countries are like the United States, thank God, at least in employment law, as far as employment law is concerned. The default rule in the US is they have like at-will employment, which means if an employer wants to fire you, they can do it anytime for any reason, unless your contract says otherwise. And so it's really, really easy for like a company that wants to downsize in the US to fire like a bunch of workers. And the legal system doesn't like put any like obligations on them to do any of these things. Whereas in Japan, it has to basically be like a last resort. The companies can only do when they've met these conditions. And so the result is like you'll notice like mass layoffs. Reading the news, like when there's like an economic downturn in Japan or something, you only very, very rarely read any stories about like mass firing or downsizing. Like in the 1990s, when lots of companies were doing like really, really bad because of the bursting of the economic bubble, there wasn't like a massive spike in unemployment and mass firings. There were some people who lost their jobs, but not as much as you would have had maybe without this type of rule. So this is one good thing about employment law, I think, is that employers are generally like the law protects employees from being terminated through these types of routes. And I should mention too, like one of the if you do get fired in contravention of one of these, you can ask for your job back. You can ask for the court to order you to be reinstated. Like in some other countries, that's not possible. Like in my country, Canada, also in the US, you cannot sue to get your job back. If you've been fired, even if the employer didn't have a right to fire you because they're violating like some rule of employment law, you can sue for money for the harm that they caused you, but you cannot sue for your job back. In Japan, you can get reinstated. Like that NHK guy, he got his job back. so that's another thing to note about employment law here. Another issue like is long-term employment. So for people in like regular employment, like as I defined it earlier, permanent full-time positions, a substantial amount, not the majority of workers, but I think it's like roughly 20% is the most recent like estimate I've heard, are in this kind of like implicit contract that when they get hired by a company, their job will last them until they retire. And like employees of like large companies like Toyota or something, most of them are people who work there for their entire careers. As a result of this kind of like implicit contract means it's not explicitly stated in their contract that yeah we'll keep you until you retire, but it's sort of like everybody knows. It's implicit. So this is one thing that makes the job market in Japan a little bit different, or maybe like quite different from for example like North America or Europe or some other countries. Like in that the career progression of people is different. You start at the company, you go through this internal promotion system, and then you'll retire when you get as high as you can get. But if you look at the profiles of like American like maybe managers and stuff in American corporations, their employment is not like that. They get hired by some company like at a university. They work there for a few years. Then they get like an offer from a different company, so they jump ship and they go work at that company for a few years. Then they go to another company. In other words, people are constantly like changing jobs or changing employers. These professionals are. Actually, like regular workers are, like blue collar and white collar workers are too, but especially like white collar workers. Whereas in Japan, like that doesn't happen. I said there's like no external labor market. That is to say, if you're like if you're my age, like if you're in your 40s and you're like a manager, like middle level management at some Japanese company, there's no, you can't leave your job and go find another one at the same level because there aren't any. Like all of those jobs that you do in other companies, they're filled by people who've worked for the company their whole lives. That's where they came from. And they're not used to hiring outsiders to come fill those positions. Whereas in America, Canada, Europe, that's kind of common practice. If you're a 40-something manager, you're really good. You can jump ship and go. There are jobs out there, like similar jobs to the one you have now. Um, and you can move. There's like mobility in the labor market. So there's like good things and bad things about these two systems. I mean, the good thing like of the Japanese system is that like, I mean, if you have like a lifelong employment, it's like you have long-term security. You know that you feel comfortable. You also feel like a lot of loyalty to your company and like you're going to work really hard. Because your fortune and the company's fortune are very not fortune, but you know, like your future are closely entwined. So you have like a lot of loyalty by employees to their employers. That might partially also explain the overwork problem. Employees are expected to be quite loyal and do that stuff, but they get the reward of, at least if they're a permanent full-time employee, of you know, having job security and stuff like that. The downside of it though is like if you're in your 40s and your company goes bankrupt and you lose your job because the company's gone bust, you have no options. This is something that did happen in the 1990s. I mentioned like companies that were struggling, they didn't resort to mass layoffs. But some of them did, the companies did go bankrupt because they were having economic problems. And when you go bankrupt, it's like there's nothing left. All the employees have to leave because there's no more company. And people who are like in that situation, like 40 some or 50 whatever, manager level or even lower, but they couldn't transition easily to like a new job because there weren't any new jobs like at roughly, you know, doing the same thing that they had been doing available, because everybody who was doing those jobs were working for employers for their whole careers. There's no outsiders. And so you had a lot of people, well, I don't know how many, but you have these anecdotal, you know, you go to, in the 90s, if you talk to taxi drivers in Tokyo, you'd find some of them were like people who had been, you know, corporate executives just a couple of years before, but their company went bankrupt and there's no jobs for corporate executives. So yeah, they just did whatever they could. So there is that downside to that sort of thing. And then there's also arguments about like, you know, economic efficiency and stuff like that. Like the argument in favor of the American model, like making it easy to fire people whenever you want, is that it also kind of makes it easy for you to hire people whenever you want to, because you're not worried about having this type of commitment. If you have to hire someone knowing, oh, I'm gonna have this person for like 40 years, that's a big commitment, and maybe companies will be reluctant to make that commitment. Whereas if you hire someone, you know, if the company has a rough time in a few years, I could fire this person really easily. You feel more confident in hiring people. Maybe you'll hire more people. You'll create more jobs. They might not be quite as good jobs, but there's more of them. So that's sort of like a critique of this system that might actually discourage the companies from hiring too many people, because they're worried, as soon as we hire too many people, we're going to keep those people forever until for the rest of their lives, as there's a big commitment, and we were a bit commitment shy. So anyway, that's another issue though that comes up in Japanese employment. Demographics is another one. So this is something that's kind of been running through several of the classes we've had. Lots of old people. Japan's like facing like a labor shortage, and it's likely to persist for forever, I guess. You have like a working age population that's getting smaller and a retired population that's getting bigger, and so who's going to do the jobs? Who's going to do the work? And so there's several different like avenues for like trying to like increase the workforce in a context where everybody's getting older and the population itself is getting smaller. One is the elderly. There's mandatory retirement ages, like as an employee of Nagoya University, I have to retire at 65. If I'm still here when I'm 65, as do all the professors. This is mandatory retirement ages. But what do people do after that? And you know, like extending mandatory retirement age to later is a bit unpopular, but like providing employment options for people who retired is one. Foreigners, we talked about this in the immigration and nationality law class. You know, importing workers to work is another. And of course, female. Like I've talked about, there's a huge gender discrimination. Females are very underrepresented represented in regular employment. And so government policies have tried. Oh, and the other one I don't have on the slide is like robots and AI, replacing human workers with non-humans who all this employment law stuff is irrelevant for. So governments are like, you know, experimenting with like varying, you know, policies to try to promote these. I talked about this in the immigration law class, but the degree of like effectiveness and enthusiasm with which the government is pursuing these tends to vary quite a bit. Elderly people are a very powerful demographic in this country. Not all of them want to work, so they sort of limits on the ability to promote that. Also, like the types of jobs, physically, it's difficult to do some of them the older you get. And as we talked about gender discrimination, like that is still an issue that's affecting female workforce participation in this country. And yeah, it should do better, but unfortunately, that's the situation. These things are going to have to change, though, in the coming years, because unless AI, unless AI takes over everything, I hope it doesn't, but something's going to have to be done about the labor shortage, and it's going to have to come from one or a mixture of these demographics. And then this like final issue that I'll mention here is contract workers to permanent workers. So permanent workers, I mean like regular workers, like full-time permanent workers. And like I mentioned when I talk about discrimination, gender discrimination, there's a big difference between contract workers or like part-time workers who don't have like long-term security on the one hand, and then like permanent lifetime employees who have like a full-time job that lasts, you know, until they retire. And I mentioned that, you know, roughly 20% of the workforce falls into that permanent worker category. Or in fact, that's not quite right. Lifetime employment applies to that, but a large portion of the population doesn't have permanent jobs. They're in some form of precarious work, part-time or maybe full-time, but like with a fixed-term contract. And the government wants, and this is a good policy goal, I think, to transition away from these precarious forms of employment, like especially contract work, where you're just in a short-term employment contract, to get more employers to hire people as permanent employees, where they have job security, they have, you know, avenues for promotion and wage growth and these sorts of things. So in 2018, they passed an amendment to the Labor Contracts Act. This is like a separate. This is not the Labor Standards Act. It's the Labor Contracts Act. So this is a law that deals with like labor contracts specifically, and it added Article 18 to that, the current law. And what that law says is that if you've been employed continuously with the same employer for 5 years as a contract worker, like not permanent, like 1-year contracts for 5 years or whatever, as soon as you get to 5 years, you have a right to demand that you be turned into a permanent employee. So you work as well, these precarious positions for 5 years with the same employer. As soon as you get 5 years and 1 day, bam, you have this right to become permanent, and you have job security for the rest of your life. This became a right that applied to all workers. So clear intention was positive. One issue sorry, I said this came into effect in 2013, like 11 years ago now. That's good. One issue that came up though was that you get this right when you hit 5 years, but there's nothing in the rule that says an employer has to keep you for 5 years to allow you to get over that 5-year goal. And there's been two things that have been happening since that came into effect. A lot of companies have been honoring it. They've been, if they have like contract workers who've been there for 5 years, they're converting those people into permanent employees. Partly that's driven by the labor shortage. They need to keep those people, and so they do that, and that's good. But some employers, they've been hiring people for contracts that last like 1 day less than 5 years. they deliberately, because if you're on a short-term contract, like say you have like a contract for 1 year, at the end of that 1 year, the employer just, if they want to get rid of you, they don't have to fire you. They just don't give you a new contract. So they don't have to terminate anything. They don't have to terminate any contract. All those rules protecting you from being fired that I talked about earlier, none of that applies to you. they just don't renew you. And so what some employers are doing is saying, okay, we'll renew you, and as soon as you're about to get your renewal that we put you over in 5 years, they decide, yeah, we're not going to renew you. And this rule doesn't protect you from that. And so this is sort of the situation right now. It's it varies a lot from employer to employer. There was so as a professor, I was like very aware of this. Not here in Nagoya University. There's another university that had lots of its teaching staff on short-term contracts, and they when this rule came into effect, they made the decision that we will not renew anybody who works long enough that they would become entitled to this. And so they actually ended up like de facto like non-renewing like several thousand people all at once. Like there's a lot of turnover in their workforce. Whereas other companies, like I mentioned earlier, they decided no, actually, yeah, we need these people. We're gonna keep them. So this is a rule that was designed to encourage like a transition towards like more stable employment, more long-term employment for people who are stuck in a kind of limbo, like a kind of like short-term the precariat, as they say. And it's had some kind of mixed success. So that's the state of the law anyway. I think the economic forces, like the labor shortage, even without this rule, would probably be forcing a lot of companies to move away from that, let's not renew people, it's gonna be mean and not let them get this right, to companies and employers saying, yeah, actually, we need to keep people because there's not enough people in this country. So that's also having like a big impact. Anyway, I'm going to finish here. So I just wanted to introduce you to these issues in employment law. There's like, as you can see, there's quite a few different things that pop up that make employment law quite different as an area of contract law from buying a bottle of soda at a convenience store or whatever. So I'll finish here. Have a good week, or it's the last class, so have a good life, and I'll see you on the exam.